I see Mr. Olmos. I see Ms. Tina. So in regard to this matter, I just wanted to let you know, one, I don't know if you got the email that I sent to both of you that explained that I'm recusing myself from hearing this matter. What I need to find out is whether Judge Basher is able to hear it. I have not heard back from him yet. So you're going to just have to hang in there, and I'll try to get you information as soon as I can here this morning. I'm waiting to hear that. But it may be, if it's going to be a while, then I may just have somebody contact you to let you know where it's getting set to. But anyhow, this morning it can't be heard. Okay.
Yes, I did receive your email, Your Honor.
Okay.
So I was aware.
Okay.
However, while I had you on the line here,
Oh, okay.
I was sorry, um, Your Honor, I was wondering if you could approve electronic service.
I can't
I've
do
had
anything. Once I recused, I cannot do anything.
understandable.
Okay. All right. So you can make that request to the next judicial officer.
And according to your email, that's going to be around 1 p.m. possibly
I
today?
don't know yet. That's exactly it. I thought I would know before I stepped on this morning, and I don't know yet. The judicial officer I thought might be hearing it at 1 is still in a hearing, so I can't talk to him to find out if he's able to hear it. Okay. All right. We'll get back to it.
I believe so, Your Honor. Making Gilmore on behalf of the petitioner and non-moving party, namely Timothy Fraggle.
All right. And
Marcella Renee Fragel, respondent.
thank you. Just a second here. So I wanted to find out what in particular was going on with this matter. I did not see a response. Looks like there's new counsel, so just wanted to see where things are at.
So we were before the court on the 14th for trial assignment. Judge Carney at that point set it on today's docket. My staff filed a responsive declaration on Thursday. We did present a bench copy, but I know that there's been some issues with bench copies. And so I do see that it's on Odyssey, but it's not uploaded. So the court hasn't had the opportunity to receive that. The motion, frankly, wasn't timely even for today's hearing, so we likely need to set it over.
Ms. Fragel, anything?
Yes, that gives him more time to pack my things and ruin them. And I don't believe it should be set over because it causes me undue hardship.
So, Ms. Gilmore, I do have some concerns. One, I do think it's appropriate to go ahead and set it over. I understand what you're talking about, Ms. Fragel. But meantime, Ms. Gilmore, I do have concerns in regard to the allegations and what's being said here. And I want to make sure that there is I want a restraining order in place at this time, that there's no disposing of, no selling, hiding, the usual, and no damage or destruction of any property of anybody, either party, until this matter can be heard.
Absolutely, Your Honor, I understand.
Okay, so with that, what are you thinking? I guess you already filed your response. Ms. Fragel, you'll probably want some opportunity to respond too. Do you want to set it over a week or 2 weeks?
1 week would be easiest for me, Your Honor.
Okay. Ms. Gilmore, does that work for you?
Yes, I'm already before the court on other matters.
Okay. All right, so let's go ahead and set it over 1 week. And I'm hearing somebody in the background.
Thank you.
Your Honor, are you looking at Eric Larson v. DeVita Sanchez Larson, or are you looking at another Larson? I thought we were.
Sorry, I'm looking at the DeVita Sanchez Larson and the Eric Larson matter.
Thank you, Your Honor. Your Honor, Ms. Winkles has just popped in saying that she's on the protection order docket.
Okay.
I'm willing to wait on her. That's fine.
Okay. Well, I'll recall it.
Thank you.
Who do we have? I see Mr. Sandy.
Yes, Your Honor, Ms. Hoke for Mr. Swingle.
Okay. All right, and okay. So this is on for review. I reviewed the files and record, and it seems the visits are going well. Does that sound about right?
I think they're going very well, Your Honor. We had a bit of a delay because the daughter had a surgery in January, but both parents were involved in that, and visits have resumed. So unless Mr. Zandy disagrees with that, that's where I think we are right now.
No, Judge, I don't entirely disagree with that. This is a case that's been tracked primarily by Judge Evans since last year. It's been a phased approach through a reunification standard with Mr. Swingle and his daughter. Things have kind of, again, advanced at somewhat of a slow pace. Last time we were here was in December, and parties were contemplating a rather significant back surgery for the child in January. Judge Evans at that hearing indicated that he kind of wanted to proceed with caution, set a review date to today's date to see how the surgery went, where the child is. Again, given kind of the significance of that, everybody recognized that. I think we were all on board back in December that caution was kind of the best approach. Here we are. So I can say that Quinn is doing relatively well. I did receive information from my client that although it's been somewhat of a arduous process, child is doing better and on the mend to some extent. It's my understanding that the parties, pursuant to Ms. Hope's comments, have resumed visitations to some extent. But Quinn is still on at least another 2 weeks of restricted activity. Understand she goes back to the neurosurgeon in early April to see for more testing to make sure that she's doing well and that she's where she needs to be. Still taking medication. Now that's still 2 to 3 times daily. So again, I don't know about school. I think she just recently began going back to school. Maybe Ms. Hope can provide some information on that. My suggestion on this, and I reached out to Ms. Hope, we haven't been able to touch base quite yet. This is a case that needs to get in for mediation and get these parties done and on their way. Now that Quinn is had the surgery and hopefully on the road to recovery, I think it's probably appropriate to do that. We discussed that back in the fall. I think everybody agreed, pending the surgery, that's where we were at. But nonetheless, that's where we stand. That's how Quinn is doing. It's still on the road to recovery. There's still a couple of steps to go. But again, I think everybody's kind of anxious to get this case resolved.
I agree with that, Your Honor.
Okay, go ahead.
Oh, I agree with that. We just probably need some kind of interim sketch of a parenting plan, and then we could do the mediation and get it wound up.
Well, I'm wondering at this point if you have a proposal, because I didn't see any proposal beyond the step 3 of Judge Evans' plan. I'm not familiar with the whole everything that's been going on, so I don't know if, like I said, if you had some kind of proposal that you were making, or where we're at, or if you want to just maintain where you're at and go to mediation to work out a plan. To me, that makes more sense because you're knowledgeable of what's been going on and why the steps were put into place. And so I don't know, your thoughts on that?
I mean, that makes sense to me. I honestly don't know if the daughter has been to the Tri-Cities where my client lives. I've heard from him about a week and a half ago, so I don't think so. I think he's still coming down here, and they're doing visits at his father's home in Vancouver. So we could continue that and alter it as necessary for the child if it's too difficult for her or interferes with anything with her recovery.
Mr. Zandy?
Yeah, and I don't disagree with that at all. I think that was contemplated back in December, and we had information presented from the doctors that said, travel back and forth to the Tri-Cities would certainly not be doing this child any favors in her recovery or comfort levels. My suggestion, and again, there's various ways that we can do the mediation. Now, my suggestion would be that we get into one of the private mediation centers in Longview. Understand they're about 4 to 5 weeks out. That puts us, again, in line with Quinn's recovery time. That puts us at about that April date when she goes back to make sure and meet with the neurosurgeon to make sure that the recovery is going as designed. And I think hopefully by that time we can have the information, see where she's at, and then be in a position to keep the visits the same or expand those, or whatever the parties agree to do based on the circumstances. Alternatively, we could set it for an MSC, but those are months and months down the road. So I'm trying to, again, kind of steer people towards other options, given the timing of this thing.
It seems like from what I read that it makes the most sense to just go ahead and try the mediation first and see if that can, if the parties can reach an agreement. I don't want to do a step 4. Right now you're on step 3. There is no step 4. So I'd rather you went to mediation, try to work it out. If you don't, you can bring it back and we'll go from there. But meanwhile, let's see if the parties can agree. I'd rather that than an order of the court.
Very well. Thank you.
All right.
Your Honor, if I could just, there's a post-op report that indicates that there won't be lingering issues with her traveling. I just wanted to put that on the record because I know that issue has been prominent in our recent hearings. So thankfully, it looks like she will be making a full recovery.
Okay, great. All right, thank you.
Thank you.
Thank you.
Yes, Your Honor. Good morning. Mr. Trotter here on behalf of Jeremy McFarling.
Mary English here, the petitioner.
Okay. All right, go ahead.
It looks like the GAL Keith Lawrence is also on the call.
Okay, thank you.
My name is Mary English. I'm the petitioner in this case. The respondent, Jeremy McFarling, and I were married August 9th, 2008 and separated October 12th, 2021. We have 2 children.
Okay, I'm gonna, let me, I have a number of cases. I don't mean to just cut you off.
No problem.
At the same time, I have read everything that you wrote, so let's focus on that. Okay. So with that, go ahead.
Yeah, so there's concerns about Casey McFarling, the respondent's brother, being around the children. I'm asking the court to order to restrain Jeremy from exposing the children to his brother, Casey McFarling. I know Keith Lawrence is on the call as well, ready to speak on this matter. Jeremy's trying to say that I'm using this hearing impatiently, not waiting for Keith's report to come out, but Keith actually encouraged me to bring this matter to court myself to have this matter heard by the court and ruled specifically.
Okay. All right, Mr. Trotter.
Yes, Your Honor. Good morning. I haven't seen any information from Mr. Lawrence yet in the form of a report, so I can't speak to that. But I will say that the report, the guardian ad litem was appointed back in August, and we're still awaiting a report. Some of the allegations date back to 2015. There are police reports, CPS interviews. None of those have led to any crime, any criminal charges being filed, nor have there been any founded CPS reports to corroborate any of their concerns. So I simply would say that there is no basis to believe that there is immediate or irreparable harm, and therefore I'd ask the court deny the petition.
Mr. Lawrence, any information, that you'd like to add?
Yes, Your Honor. I've had a chance to review the Columbia County Sheriff's Office report from 2015. I've also read Jared Masterson and Kyle Weber's statements that Ms. English has provided for the court. I have spoken to Mary and the children. The concern that I have, and I'm reaching back into my former position as the sex offender specialist with the Cowlitz County Juvenile Department, is that at best, Casey's behavior would indicate that he just has little to no sexual boundaries. At worst, this behavior could be described as grooming behavior. And right now, it's very difficult to tell. There are no allegations that he has done anything with Samuel or Ellie. However, I have concerns as to whether or not, as Samuel gets older, that he starts falling into the age group that Casey was trying to entice into looking at pornography and potentially sexting. And I know that Ellie has some real anxiety about being away from Ms. English. and she has resisted on several occasions going to visit her father. I did have a chance to speak with Ellie alone and asked her point blank whether her father has ever touched her inappropriately. And she became pretty animated, indicating that no, that has never happened to her. But the situation is that Mr. McFarling basically lives in a motorhome on the property of the family, but he has his visitation at the grandparents' home in Longview. And from everything I've read, it does not appear that Jeremy nor the grandparents are taking these allegations against Casey seriously. And just because there have been no CPS findings or criminal charges doesn't necessarily mean that this behavior did not occur and should not be of concern. In fact, the court asked me specifically in my order of appointment to investigate that. And so the court had some concerns at that point. And my report will be out this week, but I wanted to delay my report until after this hearing to see if the court was going to make a ruling on this situation. But if I were asked what my recommendation would be in this matter, I would ask the court to consider not allowing Casey to be around the kids when they're over there for visits.
Ms. English, anything further?
No, Your Honor.
Mr. Trotter, anything further?
Yes, Your Honor. Again, I'd just like to go back to the fact that, with all due respect, I understand concerns, but since 2015, again, I'd like to revert back to the fact that that there have been no charges, no findings, and now we're just hearing about concerns about abuse from the GAO. And so I'm just curious why these concerns weren't presented sooner if there was a major concern. So again, I don't feel that there is a basis for harm in this case or irreparable harm.
So with that, in regard to, I reviewed the files and record and everything that I've read, that the court has significant concerns in regard to Casey McFarling. I didn't see it or something, but in regard to the dad, I did not see the issue. So that part of it is new information, and it doesn't sound like there's anything of significance there at this point. If there's something more, Mr. Lawrence can identify it more in his report. But in regard to Casey McFarling, the court does have significant concerns. Again, just because there's not findings, just because there is not, criminal charges filed doesn't mean a thing. It doesn't mean that it didn't occur. And to say that all is good, and no, the court does not accept that. And that the best interest and the safety of these children come first. And with that in mind, based on the files and record, the court does order that the father, no one is to have the children around Casey McFarling. And I say that in part because, again, I don't, as Mr. Lawrence has indicated, the court doesn't believe that the father is accepting this as an issue. The grandparents are not accepting this as an issue, and therefore are not going to be stepping up to protect the children and follow the rules or the order of the court. So with that, minor children are not to be around Casey McFarling.
Yes, Your Honor. I just have one thing I'd like to note for the record, please. As you indicated, there was a mention of Mr. Jeremy McFarling. There was a question as to whether or not he had abused the child. And again, I'd like to just say that that is not part of the record. And so I'd like to ask that stricken or whatever needs to happen. Simply, that is not the concern here, is Mr. Jeremy McFarling.
I already indicated that, so.
Thank you, Your Honor.
All right, so with that, I need an order. Ms. English, I understand that at this point, I need you to put together an order for me to sign.
Your Honor, I believe that you do have a copy of that order ready to sign.
Let me double check here. All right, so Mr. Trotter, I have before me a proposed order, restraining order The respondent, Jeremy McFarling, is restrained from exposing any contact with Casey McFarland. Any objections to that based on my ruling?
No, Your Honor.
Okay. Am I okay to put approved via Zoom?
Yes, Your Honor.
All right. We have Ms. Winkles back. We have Ms. Dow. Okay. For the record, I have reviewed everything that was submitted. So with that, Ms. Winkles, anything you wanted to add?
I'll just make this short because my voice is gone as well. This is the case where my client's literally done nothing wrong. Apparently, my phone call set off the counselor. You've read the text messages. They're not exactly text or not exactly emails you'd expect to see from an unbiased counselor who's attempting to reunify mother and child. Additionally, the appointments being set for past in the future, you can see the dates on them. They'll be set on the 20th for a visit that occurred on the 18th. That's just designed to make my client fail. Having them at 5 p.m. when she has to drive 2 hours just to get there so that she's stuck in traffic for 3 hours is making my client, it's designing my client to fail. She already hasn't had visits. They've had one visit of 35 minutes where apparently the child played games. Not sure what I did in this case. I called the counselor because I was told this is what happened and I just wanted to see the strategy forward. Counselor freaked out. That's all I can say. The text messages are there. I'm not going to belabor the point, but what we need is a unbiased counselor. The PhD thing is really not necessary. We need somebody with experience. I think education is important in a sense, but really experience in dealing with these high conflict situations, this 7-year gap, problematic parent. Allison Long is fully capable of doing that, even if she doesn't have a PhD. This guy has 2 years of experience. Allison Long's been doing this a very long time. She was an executive in, the Division of Child Support and in DYS. Sorry, I can't remember. Additionally, we have reunification counselors here that would also do it. I haven't spoken to Allison Long to see if she's available, but it would make more sense than to have somebody that's 2 hours away that has 2 years of experience and has essentially said, I control this, let your client know. So we'd ask to change the reunification counselor to somebody that is not only more local, but will be unbiased. I don't believe Mr. Lindell has any experience in being a reunification counselor. Because clearly from having this looked at by Charlotte Rosen and others, this is just not normal behavior of a reunification counselor. So we would ask that we be allowed to change to Allison Long, who's actually cheaper as well. You'll notice the fees also went up strangely. Or I believe Charlotte Rosen has a conflict, but I believe Allison Long would be able to do this.
Ms. Dow?
Your Honor, there's no doubt that Ms. Sanderson is sincere in wanting to reestablish her relationship with her son. There's also pretty clear evidence that most of the third-party professionals who've looked at this situation and had interactions with Ms. Sanderson have varied levels of concern about her ability to control her own behavior in stressful situations, especially situations regarding children. If you look at the most recent Guardian ad litem report, that concern is all over that report. Judge Evans requested a PhD level therapist for a reason. This is therapy for a parent and child. It's not just counseling to prepare a child to deal with his mother. He is interested in having a relationship with his mother. He doesn't want to go to her home. He still has lingering fears of being kidnapped. I would like to make the point that Ms. Winkles has decided to testify in this matter in that she's submitting emails between herself and a therapist who is not talking to a client or a patient. He's dealing with an attorney who contacted him very, very shortly after Ms. Sanderson left the first session. The child is not uncomfortable with Dr. Lindell. He requested that the game that they play would be Uno. Judge Evans was very, very clear that the therapist had to be present, involved, ready to redirect at any moment if things were starting to go in a direction that should not happen with this child. This is absolutely no doubt about Ms. Rosen's qualifications or ability or Ms. Long's qualifications or ability. This is about Ms. Sanderson in a situation where she's being asked to cooperate with something she doesn't like, and she's immediately trying to change the context of the situation from the child's interest to hers. We're asking that we remain with a therapist that the child's established at least a minimal relationship with. We're asking not to disrupt this process before it even has a chance to get started. Ms. Sanderson's rights as a parent matter. Of course they do. But this is a matter of a child feeling like he is somewhat in control of what's going on. That was made very clear by the order by Judge Evans, that this would also not just be therapist-led, but also take firmly into consideration the child's concerns, his feelings, his needs. So we're asking the court to allow this process to at least have a chance to go forward, to work. Setting appointments at 5 o'clock is making things work with Ms. Sanderson's work schedule. She's going to have to drive 2 hours to get to the Longview area from where she lives, no matter what time of day she goes. We're asking the court to just give this a chance. If it doesn't work out for Ms. Sanderson, or if it's clearly not working out for the child, that would be the time to change this. This motion is asking that there be no changes allowed without input from all parties, and yet she's trying to change it right now with no input from Mr. Larson or from her son. So we're asking the court to just allow this to go forward 60 days, maybe a review in 60 days to see how things are going, rather than change people that the child is dealing with right away. That doesn't seem fair to the child.
Brief reply, Your Honor.
Go ahead.
Number one, you'll see a text message from the counselor immediately after the appointment telling mom how great it went. So that's number one. And then you have a call from me and then an immediate email back, essentially saying, I'm the one in control here, and flipping out is the only way I can describe it. We have both mom and child have their own private counselors. Again, child's only met with this person for 35 minutes. That's it. We have a declaration from my client's counselor who states how weird and uncomfortable the phone call to her was, and that he thought it was very unprofessional. We also have the emails, which are very unprofessional. The therapists are still involved here. Child has his own therapist. Mother has her own. This is not about Miss Sanderson. The issue is with this particular counselor. Again, he texted her that the visitation had gone great. This is not a gamesmanship or a strategy to try to get mom some sort of benefit here. This is a man who clearly did not like being challenged, and not even sure how there was a challenge, and took a position of, I'm in control, I'm in power, and you all need to know that. It was weird. This is not disrupting the process. There's been one visit for 35 minutes. What's disrupting the process are these emails that clearly show a bias, these emails that clearly show the inability to work with the legal system, that clearly show somebody in need of being in control, when this is not about the counselor, it's about this bond. The fact is that she gave this man, and this was in the initial report, that these dates are set because mom has 2 days that she absolutely cannot take off work. Oddly enough, after the phone call, all the remaining visits that have not occurred, all were scheduled again in the past on those days. This is not changing who the child's dealt with. The child's dealt with his personal counselor. He's dealt with this guy for 35 minutes once. So it makes no sense to keep somebody who's clearly not a reunification counselor, who's probably never done this. I don't see any testimony any different. This is a very specialized area of counseling. The person needs to know what they're doing, to do it effectively, to remain unbiased, and to protect everybody involved here. It's protecting the bond, protecting the child. I think if His Honor Evans saw what was occurring, I believe that he would also be concerned, given the high, he chose that degree because he was looking for somebody incredibly professional, incredibly experienced. And from the emails, it shows that clearly we don't have that. And it was a concern going forward at the beginning before he was selected that he had only had 2 years of experience as a counselor in family law. or in family setting, reunification counseling needs somebody very particular. We'd ask that he be removed and that somebody that can actually facilitate this process rather than just checking boxes can be placed in his stead.
So in regard to the selection of the level that Judge Evans had ordered, the court has to wonder what was going on and why, because I've not seen that before. And I'm familiar with the local people that are experienced with this kind of counseling or opportunity. So reunification counseling. So how did this particular person get selected?
Your Honor, if I may.
Go ahead.
We received a recommendation from a guardian ad litem who had worked with Dr. Lindell in a high conflict situation previously and felt that in the end, he had done a good job.
Your Honor, if I might interject, there are only 2 PhD level reunification counselors in the state of Washington and the Southwest. One is Dr. Poppleton, who unfortunately does not have any time for the next essentially 2 years. And this man, His Honor, Judge Evans wanted a PhD level because mom had kidnapped the child 13 years ago, I believe, or 9 years ago, 10 years ago. And so he was concerned that the child would remember that. That's why he was looking for a PhD level. It wasn't anything about current behavior of mom. And again, you'll see the GAL report. Nothing about a PhD level was requested then. His Honor, Evans remembered probably back that case. I believe he was the judge back 8 years ago or however long it was when mom did that. Mom has been through extensive behavioral therapy. There is a evaluation by Dr. Maharg saying that mom is no longer a danger, that mom may have trouble processing her emotions, but she's been signed off by her own counselor, Dr. Maharg, pretty much everybody involved. I think it was just a protection for the child to make the child feel more comfortable as well. But given that it's kind of the shortest list on the planet and one is not available, it was kind of a default. We did argue against it, but in the end, we had to concede because he was the only one available in Washington.
All right. So there's no question the court's having trouble here because obviously Judge Evans had something in mind. At the same time, when I'm hearing that there are only 2 people that are available to this, to have somebody who doesn't have the experience in reunification counseling is of substantial concern. And that's ultimately what the court is looking at here. I'm not sure what Judge Evans had in mind, but the court doesn't feel like it has gone well. I've thought about, well, should we try a couple more times? But then you get the child used to somebody, and then you have other issues that come up if it doesn't work. So with that, Allison Long is somebody I think the court is willing to accept. I'm not sure of Ms. Dow. Do you have any thoughts of anybody else?
Your Honor, Ms. Winkles is correct saying that the level of background that Judge Evans was looking for is difficult to find. I think a good part of Judge Evans' concern was detailed in the guardian ad litem's report about Ms. Sanderson's behavior, again, in another stressful situation involving a child. And he was looking for someone who had the training. I can't speak knowledgeably about Dr. Lindell's background. All I can say is that we were looking for someone and that I received a guardian ad litem's recommendation because she had worked with him in the past. If the court determines that there should be a change here, we would ask that it be, again, somebody local, something that disrupts the child's schedule as little as possible. And we would also ask that any intake costs for the residential parent be covered by Ms. Sanderson. My client has already paid the bill for her, 100% of the bill for her to do her intake with Dr. Lindell. This is a very difficult situation, Your Honor. That's all I can say. I don't have any previous relationship with Dr. Lindell. I'm aware of the difficulties of finding somebody with that level of training and background. I understand why why Judge Evans was very concerned. Dr. Meharg himself said that the reunification should take place in a therapeutic setting. If you look at page 7 of his 2022 report, he's pretty clear about that. He's pretty clear about his concerns about Miss Sanderson's ability to see beyond her intentions to the way she actually behaves. If the court feels that somebody local can step in on that, can handle that sort of a situation. Again, I no disrespect to any of the local reunification counselors here. We're just very concerned about this, Your Honor. This is a child who is stable and happy and has started, if you'll see from the record, has started displaying some anxiety behaviors around this whole activity, even though he wants to know his mother. He's still afraid of the situation.
And Your Honor, if I might just briefly,
Well,
Allison
hold
Long.
on. Stop. I know Ms. Long, I don't know her, but I'm familiar with her background. So Ms. Dow, remind me, how old is the child right now?
He's 13.
He's 13. Okay. And do we have another time scheduled or not?
We do not.
Okay.
Your Honor, I am not.
He refused.
Hold on.
That.
Hold on.
I'm not sure of that. I think Dr. Lundell was trying to make another appointment.
He told me that I would personally have to sign to pay his entire fee for every session as the attorney. My firm would have to pay 100% of the fee, including Dad's 3%, or we would not have any any sessions scheduled. You can see that in the emails. My firm does not do that.
Ms. Dow, let me hear from Ms. Dow.
Your Honor, he has not said that to me. I will freely acknowledge that my client is paying a very small percentage of this fee. Judge Evans had a reason for that as well. My concern and my client's concern, I think everybody's concern here, is that this child be able to have a relationship with his mother. He's expressed an interest in doing so. He's also a bit afraid of it. And we're looking for someone who, honestly, as far as my client is concerned, this could go on forever. He's not that interested in having anything to do with Miss Sanderson, but he supports his child's desire to have a relationship with his mother. Looking for another PhD level is going to be difficult. Ms. Winkles is absolutely correct about that. And it builds more delay for her client into this.
So here's what I'm going to do. One, I don't hear that this may have a PhD, but that doesn't mean he's trained in reunification counseling. That's not what I've heard. And I understand why Judge Evans may or has ordered the PhD. At the same time, if it's not available, it's not available, and you're not going to be moving forward if somebody may have a PhD but not have the training. This is an area, that's why it's so hard to find people that can do it. And ones that have the background and experience. Ms. Long may not have the PhD, but she has the background and experience. So weighing the two of which one is better for reunifying. So with that, I am going to order a change to Ms. Long. And the reunification will be through Ms. Long, that Ms. Winkle's client will be paying for the intake, whatever it was that Ms. Dow to request this change, given that Ms. Dow's client paid the other person. But just looking at everything and weighing it to move this forward, to get the appointments that need to accommodate the child, I think Ms. Long is in a better position to do that. I don't see it moving forward unless we change.
And Your Honor, I just have one other request, which was in the motion, that the attorneys only speak to Ms. Long together. There will be no sole interaction with Ms. Long, one or the other. I'm concerned about, given the history of the well being poisoned before they have the opportunity to actually come up with a plan. I have no problem for both there. or if we're both sending documents and seeing each other, but this individual kind of ex parte communication, it is problematic. And obviously mine with the counselor was problematic on its own. I just ask that we just don't have that issue again.
I absolutely agree, Your Honor. That
Okay.
is.
All right, as long as you agree, then that's okay. That can be ordered. Okay.
Presentation?
We can set it over a week and you can get me an order, agree on it.
Okay, sounds good. I can do that.
All right.
All right, thank you, Your Honor.
Thank you, Your Honor.
8. Do I still have you here?
Yes, Your Honor, I'm still here.
Okay, I have you both here. Unfortunately,
Yes, Your Honor.
Unfortunately, the judicial officer that I need to hear from is still in a hearing and hasn't been able to take a break. So rather than you sitting here and waiting, I'm going to move it to the 1 o'clock docket, which is the attorney docket B. But if for some reason Judge Basher is not able to hear it, then check your emails, because my assistant, Autumn Terry, will be emailing you to let you know when it will get set to. Okay? I'm sorry about the complications, but that's what we're looking at. I don't want you to just sit here any longer.
Okay, thank you, Your Honor.
Your Honor.
Yes.
I do have a visitation scheduled for Samantha today. And I believe it's from 10 or 11 to 1 p.m. So I'm dropping the kids off at 10:50 and picking them up at 1 p.m. But if I can attend via Zoom, I can do my best to get on the 1 p.m. docket, Your Honor. And I'm not sure if you have this information, but the last judge that we've seen also, the same thing happened. Well,
Right.
That wasn't Judge Basher, was it?
No, that was Judge Evans. So,
The last,
so Judge Evans and myself have recused, and now I don't know if Judge Basher has to as well. And so, yes, you can join via Zoom just like you did today or this morning, but it'll be at the 1 o'clock docket. And meanwhile, Autumn Terry will email you to let you know one way or the other. Is it going to be at 1? Is it going to be at a different time? Okay.
I don't think I've ever went before Basher, so I think we should be okay.
Okay. Okay. Sounds
Thank
good.
you.
All right. Thank you.
Good day. Bye-bye.
So can you move those to the 1 o'clock?
Yes.
Okay.
One last question, Your Honor. What was Judge Basher's first name?
Judge Gary Basher.
Thank you, Your Honor. I appreciate you.
All right. Thank you.
And just for the court's reference, we do have the guardian ad litem with us, Ms. Turnbull, as well this morning. This is on for our motion for contempt, as well as our motion to modify the temporary order. At this point, service was effective January 12th. We've set this matter over now more than a month. There are and continue to be pressing issues. I'm going to address the contempt first, and then sort of move into the parenting plan issues and temporary or modification of the temporary, and then kind of go back to some of the financial issues at the end. Regarding the contempt, the first very clear contempt is the failure to pay spousal support. In this case, the court found not that long ago that Mr.'s income has a net income of $10,000 per month, and this was before we found evidence of his second job. He is able to pay the support that the court has assigned to him, and he's specifically chosen not to pay spousal support specifically. This has very direct financial impacts on my client and the community finances. She was unable to make car payments, resulting in one of the vehicles being repossessed, and there's now a rearage that's owed on that car, even though it's been repossessed, and also makes it so she's unable to pay the full house payment, which is a hefty house payment, which we'll address as well. That puts the house at significant risk of foreclosure, in addition to hurting everyone's credit. The arrears at this point exceed $7,000 in spousal support. As far as the parenting plan, there are multiple contempts. When we look at the parenting plan at section 5A, the children were not to attend the homeschooler co-op group that was part of Maggie Kennedy's co-op group due to sort of the level of toxic interference that individual had with these children. And the court had really carefully tailored sort of what the children's interactions with that person would look like. and sort of really narrowly and carefully made an order in this case. And so what Mr. did to get around that is Mr. and Maggie Kennedy then set up additional new groups to involve the children in, so that the children that are being involved in these new groups with Maggie Kennedy and the homeschool group. And we see that occurring on Mr.'s Fridays on October 13th and on January 6th. These are on Mr.'s regularly occurring Fridays, where then he's placing these children back with Maggie Kennedy in this same homeschool group of children. And this is critical, not only because they're being involved with Maggie Kennedy, but they're also being involved with children that have mental health disorders that impact the children of this case. One of the children in the homeschool group, unfortunately, is a child that self-harms, that self-injures. That child and one of the children of this case then sort of feed off of each other in doing those behaviors. And so the goal was to limit these children's access to each other, in addition to limiting the children's access to Maggie Kennedy. So it had a dual purpose. And Mr. then decided that instead of obeying the court order, they would create these new groups and then push the children into these groups. This was specifically prohibited under the order. It was the children can attend things they are already doing that are not the homeschool group. So essentially, if they were going to a Wednesday night youth group, they could continue to do that. But this is not that. They created a new group and then sent the children to this group. So again, Mr. should be held in contempt for that. As to Parenting Plan Section 5A, this is joint decision-making. Mr. engaged the child with a therapist that is not her regular therapist for mental health purposes, refuses to provide my client the information, continues to refuse to provide that information, refuses to provide details of the visit, why the visit occurred, who it was with, when it was, refuses to engage in joint decision-making. Again, my client becomes wildly concerned that the child is now being medicated with mental health medications that, again, there's been no joint decision-making to use. And when we have a child that's on these medications in one household and then not in the other household, that creates huge concerns and huge problems when we talk about prescription medications. And again, this is all without my client's ability to participate, to be aware, to talk to the provider. Direct violation, very clear violation, and a dangerous one at that. This is not a minor violation. This is the whole point of joint decision-making, is so we have providers that are aware of what's going on. We have parents where both parents are aware, so if something happens during either parent's time, that parent can correctly tell another provider or an ER, hey, this is what's going on. These are the medications that are being used. My client's intentionally left blind by Mr. The next issue is school attendance. That's Section 14B of the parenting plan. The children were not to attend the homeschool co-op. They were to go to traditional school. The underlying issue of this case is Mr. homeschooled the children. He unschooled the children. The children were professionally tested. They were found to be years behind in education. As a result of that, the court ordered them to attend traditional schooling. All the children were then enrolled in traditional educational programs, either in public or private schools, and that they were to attend those and not to attend this homeschool group, both for the educational purposes as well as the problems we've already talked about. Mr. then, during his time, was pulling the children on Fridays from their traditional schooling and taking them to the homeschool group. That happened October 20th, November 3rd, and then again on November 17th. These are all Mr.'s Fridays. And so you see the children being pulled out of their incredibly necessary education, where they're already behind, where they're already needing to do heavy lifting as children to frankly catch up after years of educational neglect on Mr.'s part. And so then Mr. just decides, well, I'm just going to pull them out because it's what I want to do. So again, Mr. Direct Contempt, really just no excuse here, just does what he wants to do and moves on. Moving into Section 14D, this is involving the children in conversations and the litigation. It's clear that Mr. is having direct conversations. Some of these are happening quickly in front of my client. He's crying in front of the children saying, you're going to have to choose between your mother and me. You're going, and that they can choose. And again, these are things that A, aren't true. Children don't have this choice. And B, they don't have to choose. They shouldn't be placed in this position. This is directly emotional manipulation of the children. It involves them in the litigation. It's inappropriate on every level. And Mr.'s doing it out in the open in front of my client and in front of the children. This puts, and it's encouraging, in addition to these things, he's encouraging the children to not tell my client critical things, such as one of the children self-harming during father's time. So again, huge concern that we have a children that's engaging in self-harm. Father hides that, hides why we had this emergency mental health appointment, and then tells the other children to, be quiet about it. So again, that's involving them in that litigation. In addition to doing these things that are out in the open, he's also secreting that information, making the children direct participants with him. So for these reasons, we're asking the court to find contempt. We're asking the court to find the arrears. At this point, we'd ask the court to find the arrears of $7,113 plus interest, plus because we've been delayed at this point due to Mr. quite a bit, any additional arrears by the time of presentation, we should be able to add to that judgment. I'll ask the court for fees of $3,500, costs of $85, and a sanction of $1,000. When somebody chooses to pay child support and intentionally not pay their spousal support, they're making a very direct and intentional choice to do that. And so that warrants a heavier sanction. As far as the parenting plan, the court should modify the parenting plan at this point. It is warranted, and these children are not doing well under the current parenting plan. The current parenting plan is essentially, I would say it's like a 60-40 type of a parenting plan. Mr. has essentially expanded weekends and then a midweek on the off week that's an overnight. We're asking the court to move that to a more traditional parenting plan, which would be Mr. has alternating weekends from Friday to Sunday. In this case, we have Shiloh, who is self-harming during her father's time. We have Mr. that is hiding that fact, refusing to disclose it to my client, and encouraging the other children to withhold that information from my client. There are continued issues with Mr. And the contempt that we've mentioned. So again, those are all things that are really directly involving the children, that especially the issues surrounding school, where we're trying to get these children on track, trying to get these children to be brought up to speed educationally. Mr. is just directly interfering with that, which puts the children at risk. But it also shows the kids this, you don't have to follow the rules. You don't have to do what your teachers say. It causes all of these sort of down the line impacts to these children that are incredibly negative and make it really hard to get these children back on track long term and to be successful long term. He's involving the children with toxic individuals, and one of those is that Miss Kennedy, folks that are encouraging the children to be dishonest with their parents. Again, that's hugely problematic when we have people doing those types of behaviors. And frankly, we just have a plan that isn't working. Again, we have Mr. who has years of this failed sort of homeschool attempt and this prior educational testing that shows us that it's it did not work. And Mr.'s directly trying to undermine the children being able to be educated by pulling them out of school. The child Shiloh self-harming, we have, it should have been really a place where parents really rally, and circle the wagons and everybody comes together and everybody participates because everybody just recognizes, hey, this is really serious. And instead of doing that, Mr. then chose that opportunity to do something really dangerous and really put that child at direct risk. Essentially see a child that's self-harming and cutting and send that kid back to mom and stay silent. Put child on medications and not say anything. So child's being medicated in one home but not the other. So again, huge risks here. And again, these toxic individuals. In this case, the best interests of the children really are served by placing the children primarily, and they're already primarily at my client's home, but placing them with my client and putting changing father's visitation to an every other weekend plan. That allows for higher levels of stability for the children, more consistency for the children educationally, more consistency for them. If they need medications, my client is not opposed to medications. She just says the idea that we're going to play this game of on, off, that's crazy. That's so risky. And so the idea that we need a parent who's willing to communicate and he isn't going to play the game of, I'm going to hide whether or not the child's having a mental health issue because I think it's going to score me points in court. That's not the priority. The priority has to be the health and safety of these children. And my client's the only one who is willing to put the children first. Again, going back to the financial issues, because we are asking to modify some of those as part of the temporary orders, In this case, Mr. is already $7,000 and now more in arrears on spousal support. We're asking the court, there is a primary home. We're asking the court to order that to be sold. We do not believe that Mr. will comply. We just don't. Given the behavior, the fairly consistent behavior in this case, we can come here over and over on contempts. But as we do that, the house is going to get further and further behind. We're going to fall into foreclosure, and then we're selling it under a foreclosure or a short sale instead of selling it sort of volitionally. So we're asking the court to order it to be sold. It's logical. It has an incredibly high mortgage. The mortgage in this case is more than $2,300. That's very expensive for these two parties. It's logical to sell the home now. The estimates is that the home will net between $50,000 and $100,000. We would use those funds initially to catch up the arrears, to pay off the arrearage on the repossessed vehicle, pay off the other judgments that are in this case, and then provide some amount to each party from the amount that remains. And that's what we've proposed in our proposed order. So in this case, that's a very reasonable outcome. My client's currently in the family home. She's very willing to work to get it sold. We hope that we've proposed, I believe, some real estate agents. If parties can't agree, we can address that on presentation. But the idea that we would hold on to a home that's very expensive doesn't make a lot of sense. And especially when Mr. is sort of playing games with finances. It makes more sense to sell the home at this point. As far as child support, we're not re-arguing those numbers. Again, the court just set those 5 months ago. We don't believe there's been any substantial changes. No one has changed jobs. We did find a second job that Mr. participates in, but it's not a massive second job. It's just kind of a side gig is what I call it. So we're asking that those numbers remain, but that the court eliminate any residential credit. As far as spousal support, the same spousal support should also remain. Again, there's no basis to modify spousal support. Everybody's finances are the same, and this is a long-term marriage where Mr. has an incredibly good job and my client is making essentially minimum wage type earnings while she's going to school. As far as fees, we are asking the court for an award of $5,000 for the motion for temporary orders, separate and apart from the contempt. There were efforts made to avoid this hearing. We shouldn't be here. We're here largely because Mr. Yanez just won't follow court orders. He is going to do what he wants to do. And so, unfortunately, we're in a position where we then have to react and address those things for the health and safety of the children in this case. There's also a significant disparity in income between these two parties. Mr. makes $10,000 net before we're calculating in his second job. My client makes about $2,000. So he makes about 5 times what my client makes. It's very reasonable to award additional attorney fees. And again, those can be taken out of the proceeds of the house sale. So again, we're not necessarily even trying to get them out of Mr.'s pocket. We don't really believe he'll pay, but because the court can order the home to be sold, that is a way of accessing those funds. And so with that, we are asking the court to grant the relief we've requested, and we do have the guardian ad litem that can give the court input as well.
So, Mr. Yanez, this was set over in part to allow you an opportunity to respond. I've not received anything from you. Did you file a responsive declaration?
Yes, Your Honor, I did file a declaration.
When?
On Friday.
Ms. Baldwin, did you receive a copy of that?
I did not receive
that. Ms. Yanez or Mr. Yanez, wait.
I did not receive a copy. I checked my email this morning. I checked Odyssey as well, and I don't have a hard copy. So I've checked every vehicle that I could check to see if there's any copies.
Your Honor, it was sent to a Miss Lisa. I'm checking the name here. Lisa. I apologize. Just a moment. Just a moment, please.
It's okay. I can verify. It went to my. It went to. So my staff did receive it. It looks like it went to spam because it's 105 pages that he filed. Looks like on. Let me ask when it was received.
Friday at 3:19. It was sent.
Okay. I don't have any reason to dispute that. So Friday at 3:19.
And I have not seen a copy of that either.
I would ask, it's not reasonable for him to have filed it Friday at 3:19. It's just not reasonable. In this case, we've set it over already for him. Even at the last hearing, we were a month out. We're more than a month out at this point. It's just not reasonable to keep pushing it down the road when we have young people with some pretty significant issues.
Mr. Yanis, it's not timely under the local court rules. I'm not going to consider it. We have page limitations that I don't know what you have in 105 pages.
It wasn't 105, and the court's clerk received it on Friday afternoon, and she made no comment about the number of pages.
Well, that's not her job to comment on the 105 or whatever number. That's not her job to do it. It's my job as the judicial officer to say, one, it's not timely. I set this over to give you significant time to respond to all the allegations and timely respond, and it still wasn't done. So I won't be considering, Mr. Yanis, stop. So with that, I am not considering your affidavit or declaration that you filed. It's not in what is our system, Odyssey system. So I will not be considering it. Ms. Turnbull, anything you'd like to put in?
Not at this time.
So I've reviewed what the court is accepting as the documents that have been filed. Mr. Yanis was given more than enough time to properly respond, did not timely respond. So it is limited to the declarations that were filed by on behalf of Ms. Yanis, as well as any input of Ms. Turnbull. And so based on that, based on the files and record, the court does find the petitioner husband has failed to obey the orders of the court as stated by the respondent wife. He had every ability to comply with the orders in the past and now, and such failure has been willful and intentional. These are orders that must be followed. There isn't a choice. Do not pay maintenance. It is only going to damage your children. You will pay the back maintenance in full of $7,113.86 plus interest. There shall be a civil penalty of $1,000 to be added, plus $3,500 in attorney's fees and $85 in cost. As a result of the contempt, the failure to comply with the orders, the court has substantial concern for the well-being of the children, including your failure to follow the requirement for limited contact with Maggie Kennedy. You have blatantly disregarded this prohibition. Further, to take the children out of school to attend Maggie Kennedy's co-op when the children are already so far behind in their schooling is again harmful to your children. As well, to involve the children in the divorce is damaging to the children. You may think you're winning them over. The children have a right to love both parents and not be torn apart by adult matters. Therefore, the court is modifying the current parenting plan and adopting the proposed amended parenting plan. That in turn means child support shall be modified to reflect the reduced overnights as set forth in the proposed child support worksheets of the respondent wife. In addition, the home will be sold. I'm adopting the temporary family law order with the modification in regard to the attorney's fees that I've ordered differently.
Your Honor, I do have a question for the court when you're ready.
It'll be a minute. I'm adopting the amended temporary parenting plan. All right, Mr. Yanis, you had a question?
Yes, Your Honor. I know, unfortunately, you didn't get a chance to look at the evidence that in relationship to the spousal support. I have already paid that. And so just from a semantics standpoint, am I being ordered to pay in addition to what I've already paid, or because it's all being garnished through DCS? So
if he's paid an amount, DCS will provide credit and then we can verify. I haven't seen that verification. So if and when it's paid, then we'll do the satisfaction.
To date, she's already received $16,000. So I'm, and I presented the evidence in my declaration, but I understand you didn't get to see that. So I just wanted to understand the semantics around, do I pay an additional $7,000 on top of what I've already paid?
It's not an additional. No, okay. It's not an additional. You'll be credited for amounts you paid.
Okay, great. Thank you.
And then the only other issue, Mr. Yanis had referenced not today and not in any materials I've seen today, but referenced using Our Family Wizard. We're happy to do that. I can just prepare a separate order, Mr. Yanez, that agrees to use Our Family Wizard. Or if Judge Haan wants to, she can just add that onto the last page of the parenting plan.
I'll just add it.
We're already using a Talking Parents app, and that's been working.
That's fine. We can add just Talking Parents. You're gonna just add that to the last page. Parents to communicate via Talking Parents. That is agreeable.
Your Honor, there is one other question.
Oh, hold on.
Sure.
Ms. Baldwin, where are you talking about?
If you want to add it in, I think a good place to squeeze it in is page 9 of 10 of the parenting plan, right above right around line 17, where it says proposal. Yeah. There's kind of a little empty space right there.
All right, I added in a line. Parents will continue to use Talking Parents to communicate regarding the children.
Perfect. Thank you.
All right, I've signed the orders.
Thank you, Your Honor.
Your Honor, one other question.
I can't now. Oh. I think Ms. Baldwin left. Oh, Ms. Baldwin, are you still there? Go ahead, Mr. Yanez.
So in my declaration, I did ask, I don't know what the process is, but I asked my previous attorney to go into mediation and wanted to know, is that a process that the court orders, or how do we get into mediation?
So I would talk to Ms. Baldwin and see if that's something that you can possibly do. I don't know if they're open to it or not, but why don't you reach out to Ms. Baldwin and ask her that?
All right, thank you.
To address that.
Appreciate that, Your Honor.
All right, that concludes that matter.
This is the opposing party.
Oh, are you the party?
Yeah. The party.
Oh, I'm sorry. My eyes weren't focusing. I apologize. All right, I have 2 matters that are on I'm not sure the one matter. All right, so that brings the only matter on for today is the new motion for contempt. So, Ms. Holder, I did want to address the one issue that Ms. Gardner had raised about the timing of this matter being on. Did you see that part?
If you could refresh my memory, Your Honor.
It has to do with local court rule 88 and the timing of domestic relations motions.
Is this in regards to this hearing or in this motion, or is this in regards to the previous contempt?
My understanding is it had to do with this motion because there was no request to shorten time to set it on for today.
Please forgive me. She filed quite a bit, and I'm not sure what was overlapping between the last motion, this motion, and the motion for next week. If Ms. Gardner wants to set this case over, she has already responded, so I'm not sure if she would require more time to respond, as she has already responded. But if it is an issue of timing and not setting the hearing out properly, I would be amenable to whatever the court would like to do.
So, Ms. Gardner, I saw that part. I think you're correct on it. As far as the timing, you did respond, so it doesn't dismiss it. It still has it going forward, just not today.
That's fine. I was just wanting to think about how come I was told and read that for contempt papers, they always have to be brought to you. I had them mailed to me. I didn't get them even before court last time.
Okay, we're not talking about last time. We're just talking about their motion.
Okay.
Your motion, your request to set aside the prior contempt that was a week or 2 weeks, whatever it was, that's, you put, we call it noted up. You noted it for next Tuesday.
Okay, I'm okay with, as long, and if you haven't had time to review all the papers, I'm okay with going for next week.
Yeah, I've reviewed everything. That's not the issue. I missed that yours was on next week, so I reviewed it too. But But if you want to set, she's just said if you want to set yours or theirs over to next Tuesday as well, that's fine too. So it's really your call.
I would contend that we are already all here and have been here for the last 2 hours, and you've already read everything.
Yeah, I get it. But at the same time, she did properly call up 88.
Yeah, I've found several things that I feel weren't done right. So I'm ready. I've been told that there's a CR5, there's a CR6, the CR 88. They're all violated. So I'm just going to point all those out. I have a whole list of things that weren't done right.
Okay.
And they're all in the paperwork.
All right. So if we're going to go forward today, then I'm going to first go to the motion to set aside and or reconsider. So that's your motion. So let me hear what your issue is on that.
Motion for contempt could not properly be before the court and is frivolous without merit. No contempt order exists by the court on 1/16/27 or 1/16/24 in the court file. Not in the interest of justice in bad faith assertion by respondent. Respondent's sworn declaration to counsel as officer of the court, both cases, their contempt claims upon frivolous and meritless claims of contempt court signed by the court 1/16/24, which was false, and no order can be placed within the clerk of court files. No docket notice was filed or served upon the petitioner for today's contempting of court, a violation of due process and the civil rules of procedure and local court rules. No order was even given, signed by the judge for me to go to court. And I also have the CR5, the CR6, and the CCL CR 88 were violated by counsel concerns, filings, timelines, and services of notice of petitioners of all in bad faith.
Anything else on that matter?
Motions brought within the reasonable basis. No signed order on January 16th. The court shall order moving party to pay non-moving party costs, fees, and penalties.
All right. Anything else on that motion to reconsider or?
I just don't feel like I had any time. I didn't even know what happened. And I came in here with nothing because I still was never served from the last court order.
Counsel?
In regards to the motion to vacate the previous order, my understanding, and I am new to practicing in Cowlitz County, is that while it's preferred that there be personal service for contempt, it's more of a guideline, and I do apologize that it was not personally served. However, she did have notice. We went to a hearing the previous week on the 9th for a motion to modify child support. She brought up the fact that she had been served with this. She also brought up the fact that her motion to modify the child support was retaliatory in nature. She also responded on December 28th to the original motion for contempt. So she did have notice. She did appear. She's claiming in her motion to vacate that there was no personal jurisdiction. She lives in the county. She appeared in court and she responded to the motion. So there was personal jurisdiction. And to that extent, she waived it. She did have notice because she did respond. She had all the opportunity in the world to respond with the evidence that she now puts forward in her motion to vacate, which most of it did exist at the time. She filed her response with the exception of two things, that being an email that her daughter allegedly wrote, which followed the proceeding on January 16th for that contempt motion. And the second thing that she alleges existed at the time that she should have been able to present as evidence was the fact that the daughters were in counseling, when she then later states in her declaration in support of that motion that she has since that hearing gotten the girls into counseling. She also raised the issue that there was no notice that she should have been, or no court signing off that she should have been served by publication. I think she conflates the difference between personal service and service by publication and service by mail. We did mail her the motion for contempt and we set the hearing. She also never addressed the issue of lack of personal service at the first hearing or in her responsive declaration. She did bring up the issue of notice at the first hearing. And if I'm not mistaken, Your Honor asked her very similar to today, well, you're here, do you want us to move on? And just like today, she said, okay, let's go. So for her to say that we acted in bad faith is incorrect. If she had brought these issues forward at the time, just like today, I would have been amenable to set the case over. And in fact, it was brought up previously that we incorrectly set the date too soon. We then set a different hearing date a week later to give her time to respond, which she did. So I'm not exactly sure why she is now filing a motion to vacate the original order. She hasn't even been following it, number one. But number two, my best guess, Your Honor, is it would appear that she's trying to vacate that first motion for contempt, and she filed it after we filed the second motion for contempt because she just doesn't want to deal with the consequences of being held in contempt twice within 3 years for the consequences of the possibility of modifying the parenting plan. So I'm not exactly sure where her argument goes as far as she had no notice because she appeared, she responded, she made arguments in court. And to say that she didn't have adequate time, she could have brought that up at the hearing. And I'm sure Your Honor would have also set the hearing over as well as I would have. So I'm not exactly sure why she felt the need to file the motion to vacate. And then on top of that, I truly believe one of the reasons and the main reason, two reasons that she wanted to file that motion to vacate was one, to just erase that first judgment against her. But secondly is because she's trying to financially exhaust my client. We haven't even gotten to deal with an underlying issue that my client hired me for, which was to modify the parenting plan. And so we've been dealing back and forth with all these contempt motions and now a motion to vacate that we haven't even really gotten to the underlying issue that would really benefit the girls in this situation. And for that reason, I think that the motion to vacate should just be dismissed.
So any response?
I believe she was right. She just said she doesn't know how Calais County Court works, and she's violated all these different things. And the day I came in, I hadn't talked to a lawyer, haven't looked into things, and now that I have, there's too many things that she did wrong. That doesn't make it okay.
So in regard to the contempt matter, the requirement as far as service is something that depends on what it is being requested. It depends on what type of thing is being addressed. In particular, I'll say maintenance requires personal service. There's no maintenance involved in this. In regard to if there was a request or for jail time or criminal type responses, such as a warrant, that was not requested. That was not before the court. The court didn't order it. Bottom line is the contempt went forward. None of these objections were made at the time of the hearing. And to bring him up now is untimely. And so for that reason, the motion to vacate is denied, and that matter is dismissed.
Can I say something?
Go ahead.
I got the paperwork the morning I got here. So how did I have time to do it?
You responded.
On the first part, the first day we were here, I had to go.
The last time that we were here for hearing, you responded. You said, let's go forward. We did it. So I'm not going back in time. I'm not going to argue with you. So as far as that motion for contempt and the order stands. So next comes the order itself. Orders and getting signed. Let me find it. January 25, 2024, it shows in Odyssey. There is a contempt hearing order. And Ms. Gardner has indicated she didn't get to see it, that is my writing. And if I know what an order is to include and it meets with what I have ordered, I signed it. And I just simply put, you appeared at the hearing. So is there something in that order you say that I didn't order?
As we thought the dates were wrong, they were filed wrong. It said the 16th and it was supposed to be the 25th.
I'm sorry, what?
Everything she put in was done on the wrong days. It was supposed the 16th and it wasn't signed until the 25th.
I don't see what you're talking about because I didn't sign it till the 25th?
Yes.
Okay, I think you're mixing up the two. Yes, the hearing was on the 16th, and I just didn't sign it till the 25th. That's not unusual.
I was told that until it's signed, I'm not in contempt because it doesn't start until the order is signed.
Okay, now you've jumped to the other contempt action. Okay. So we'll get to that issue here in a minute. Okay, so the order wasn't signed until January 25th, 24th. So the issue that you're talking about now relates to the current motion for contempt, which has to do with how can you be in contempt if there's not an order in place. All right, so the order stands as currently entered because that's a different issue that you're talking about. Now let's go to the new motion for contempt. So I want to note one thing is there was an objection to the affidavit of Bradley Randall being signed. It is attached and will be accepted. So I want to make sure that's understood. It's just simply a face sheet that has the declaration. Again, we do that all the time. Okay, so that's appropriate. And I'm talking about the declaration filed on February 13. Okay. So with that, council, this is now your motion. And just so you are aware that I am concerned that the order itself didn't get signed. And unfortunately, just there are a variety of reasons why. Whether someone can be held in contempt of an order that's not signed yet.
Understood, Your Honor. Despite the fact that the order hadn't been signed until the 25th, Mr. Randall still has not seen his daughter since October and since you ordered it. So while I understand the argument that the order is not in place until it has been signed by a judge, the fact that it was signed on the 25th and he still has not received any of those court-ordered makeup dates on Tuesdays after school is very concerning. And so I don't particularly take her argument very seriously, because if her argument was, oh, there wasn't a contempt order in place, and then as soon as the contempt order was signed, then she began complying with it, that would be a different argument. But that hasn't happened here. Mr. Randall still has not seen his daughter since October. He did not receive a single one of the 4 court-ordered makeup visitations on Tuesdays from after school until 8 p.m. This past weekend is when Mr. Randall's regularly scheduled weekend visitations were to begin. He also did not receive that. So I don't think that Ms. Gardner's argument holds much weight here for those reasons. She still hasn't filed the contempt motion that you signed. In the meantime, she did file a motion to vacate, but she has not filed a motion to modify the parenting plan. She hasn't filed for a GAL, as was mentioned on the January 16th hearing. We could have filed for an additional 3 or 4 contempts at this point, but we didn't because we wanted to get to this court date and to have the court's input on what happened at the last hearing for contempt. The issue here is that Ms. Gardner has not made any efforts to work at facilitating visits with Mr. Randall's daughters and himself. She understands the law to some extent because she did quote and use ride out. So she does understand that children, it can be difficult to facilitate those visits, but she's still not doing it. As you can see from the evidence that we put forward in Mr. Randall's declarations, he makes an effort to get to the school. He lets Ms. Gardner know that he is there. He asks where the girls. She'll say something to the extent of I'm at work or I don't know. He'll then say, well, what have you done to, encourage them? And then she will immediately call him so that things aren't in writing. And she will threaten to ruin him financially. She threatens to make abuse allegations against him. She says, I'm not going to punish the girls because they don't want to see you. So I understand that it can be difficult for teenage girls to have that type of relationship and bond with their parent, especially after there has been some length of time and one parent is allowing this type of behavior to happen. It is very concerning to me and my client that Ms. Gardner just doesn't want to follow the parenting plan, and she doesn't want to follow the order for contempt that was put in place on January 16th or signed on January 25th. I think she's literally throwing everything against the wall to not allow the parenting plan to be followed. And it's very concerning that my client still has not seen his daughters since October, and Ms. Gardner's not doing anything to make it happen. And for that reason, we would ask that she be held in contempt again, because even if the court ordered contempt was not signed until the 25th, she still has missed visitations for 3 weeks after that and for his residential time this past weekend.
It's my knowledge that you said that he's picking up from the school. I'm a third party at that. How am I even involved? He went to the school, so them not going with him, how is that anything to do with me? I told them to go, they didn't go. They went out and told them they weren't going. We're trying to do everything we're supposed to. I messaged him and said, okay, they're not ready. Do you want to meet up for dinner with me and the girls? He did not want to do that. So I am trying. The counselors told them their dad can no longer send them these letters because they break down and cry and have anxiety attacks. So no, the school has not given their letters that he sends them. So now the school is involved. There's a way more to this whole story than just this contempt and seeing him. And if you read through the paperwork, there's some huge actual problems.
Anything further?
Yes, I also find it very concerning that Ms. Gardner has put declarations and notes written by the girls to the court into the court record. It is concerning on so many levels that she's involving these children in litigation on top of basically saying, what can I do? And saying, what can I do? But then also putting that information in front of the court. I have not been informed, and I have not seen any kind of declaration or anything or any communication from Ms. Gardner that would indicate my client has been writing letters to the girls and the school has stepped in. That is all new information to me. What my client does is, per the court order, he goes to the school, he waits for the girls at drop-off, they're nowhere to be seen. He then messages Ms. Gardner and said, I'm here to pick up the girls, where are they? And again, she'll respond, well, I'm not there, I don't know. It's the same thing that you just heard. So I genuinely do not know what to do, Your Honor, at this point to ensure that my client gets his residential time, gets to see the girls, because it seems to me there's always going to be some excuse of why it's not done. And as far as saying that there's a lot going on that we don't see, there's plenty of time and opportunity for Ms. Gardner to file for a motion for a guardian ad litem, to file to modify the parenting plan, to submit evidence and declarations that support both of those motions, and she's not done it yet. Instead, what did she do? She went and filed a motion to vacate the first order. She didn't take the time to file for those other two motions. Instead, she just wanted to overturn the order of contempt. And I think it is very concerning that she wants to involve the girls in this litigation to the extent that she's putting allegedly their handwritten notes, letters, emails into the court record.
Here's what I'm going to do today. I'm going to reserve on the contempt. And what I'm going to do is I'm going to appoint, I'm going blank on her last name. It is the court's guardian ad litem, essentially, to investigate and look into, because I don't think we're going to get a true story until we have some input from a guardian ad litem. And this is just a short-term guardian ad litem to talk to the girls. I do not want any discussion about what's going on. This is up to the guardian ad litem to have contact with these girls and try to find out from their perspective and what they feel like and what they're thinking. And then go from there. And part of the other thing that I want Jen to do is to make a recommendation if we need more of a long-term guardian ad litem, because she's only short-term. What is her last name? She's new. I apologize. I'm really bad at name. Schaefer. Thank you. Jennifer Schaefer. So if you're contacted by Jennifer Schaefer, that's who it is. Okay. She'll contact each of you. For now, I'll have the cost at 50-50 as to her expense. And then I can reconsider that more down the road once I know more. And then I'm going to set this out. Let's see, we're on the 20th to March 19. Because unless I find out something else about what's happening here, is again, these children, and they are children, don't have a right to decide whether or not they have contact with another parent. And so some people think that at a certain age they get to decide. They do not get to decide. And that needs to be understood. They don't get to make a decision for themselves as whether they see the other parent or not. Meanwhile, I'll have the guardian ad litem investigate this and come back, and then I'll relook at the contempt matter. And then I'll also, more importantly, look at what needs to occur for next steps to re-engage these kids back with their dad.
So is March 19th the next time we'll be here?
Correct.
Is there any way you can have it the Monday before or after, or Tuesday, whatever you do?
Well, I don't have a problem with the 27th.
Okay. I just will be gone that day.
Yeah. Or no, sorry. Make sure I'm looking at the right dates here. 26.
And that's a Tuesday?
That's a Tuesday.
Okay. Thank you.
So you're going to see an order coming through where I appoint Jennifer Schaefer. I will just be signing it so I can get her on board and get her moving. She'll probably need releases from each of you just so contact can be made with the children. And other than that, I'm sure she'll be talking to each of you as well.
Will she be calling us or emailing us, if you know?
Probably a phone call.
Okay.
So she's going to need your contact information if it's changed. With that, yeah, she'll be in contact with you. Okay.
Sure. I do have one question about fees on the motion to vacate. I do believe I asked for $2,000 on fees to respond to that. I don't know if it would still be appropriate to award fees to respond.
Well, at this point, I'm not going to be ordering fees. I think that there's been some confusion about what needs to happen. I understand Ms. Gardner is pro se and it gets complicated. So I won't be ordering any.
And as far as the 750, I'm supposed to pay him in a certain amount of time from the other part?
I don't recall if I set a time frame on it.
I'm just wondering because he's behind on the volleyball, so it's kind of I see it as like wash. So
I'm not going to do a wash.
Okay, that's fine. I just didn't know how you did it.
Yep. No, needs to get paid.
Okay. So then if he doesn't pay the volleyball, I have to take him back on that contempt? How does that work?
So that's a separate issue that's not before the court.
Okay.
All right. That's it for today.
Thank you. Thank you.
Noelle McLean appearing on behalf of the petitioner Athena Larson.
Good morning, Your Honor. Anne Margaret on behalf of Ryan Larson.
Okay.
Good morning, Your Honor. I'm Heather Kale. I'm the guardian ad litem.
Thank you. All right. Counsel, go ahead.
Thank you, Your Honor. At the outset, I would note that it's my turn this week. I'm not feeling very well, so I ask for a pardon ahead of time if I sound a little... Anyway, thank you. We are essentially asking the court grant our request regarding signing the order, adopting all recommendations from the GAL. We have also submitted records showing compliance with certain of the requirements. Ms. Kale requested that my client perform only one of the seminars, which he has done, and we've submitted those. We're also asking that you deny petitioner's proposed new parenting plan and instead interlineate with our requests for the extant temporary parenting plan.
Ms. McLean.
Thank you very much. I'm going to be a little more verbose than counsel because I think it's important to outline what's happened as far as this case is concerned. We are asking the court to adopt our amended temporary order proposed parenting plan. And I'll note that originally Mr. Larson in his motion basically was claiming that he wanted to have the guardian ad litem report adopted, and yet his order and the motion itself basically cherry-picked certain portions of those recommendations. It's notable that he only participated in the parenting seminar after we filed my client's reply declaration. He participated in a unilateral substance abuse evaluation with no collateral input from my client, the guardian ad litem, and he even participated in his own UA that he supplemented or provided to that drug evaluator. I'm not certain why that is, but certainly it wasn't a random UA. He has not commenced the counseling that was recommended by Ms. Lovely in her evaluation that was submitted over 3 months ago. And Ms. Lovely's evaluation submitted Mr. Larson to various testing protocols. And as part of that, the testing protocols found that Mr. Larson was not being honest in his disclosures and his answers to Ms. Lovely's questions. He essentially was faking good, which isn't uncommon in these types of circumstances. But what he needs to understand is that based on the evaluation from Ms. Lovely, he exhibits his own controlling behaviors within a relationship. In his declaration to the court, he attempts to suggest that it's my client who is the controlling one. And I would submit that even looking at the declarations and the documentation, clearly you can see instances where Mr. Larson subverted the parenting plan, did not communicate directly with my client, and instead chose to communicate with these parties' 7-year-old child and the maternal grandmother, arranging for visitation outside of the existing parenting plan rather than communicating those things directly with my client. Mr. Larson presents with angry outbursts, emotionally abusive behavior, and that continues today. He clearly has or lacks empathy for my client's current situation. And even Ms. Kale's report, when you look at her guardian ad litem report at page 14, her report identifies Mr. Larson speaking about Ms. Larson and her medical issues as what has been his sacrifices and his needs rather than what's in the best interest of the child. It is accurate that my client was inpatient hospitalized. She's currently in outpatient clinicals. And during that inpatient, Mr. Larson did come down to the local area and stay in the maternal grandparents' mother-in-law quarters, as it were, to be able to spend some time with Rue. We believe, and I think his reply declaration indicated that he had taken some medical leave in order to accomplish that. But again, those are things that he needs to communicate with my client. My client tells you that in her current medical fight and communicating with the involved professionals who handle these things on a daily basis, their recommendation is for things to be maintained status quo as much as possible for a child. Maintain their schooling, maintain their counseling, maintain their friends, maintain their environment, because that's going to help them weather the different things that come about as a result of my client's current medical issues. As my client tells you, Rue does have a school routine. She meets with her school counselor weekly. She has a group of friends that she participates with, and she has Taekwondo that has been a consistent in her life. Those are things that should continue for her so that she has the best possible opportunity to weather this medical issue with her mom. Now that my client is in essentially outpatient yet in clinic treatment, my client's parents bring Rue up to visit her on the weekends. So she's able to maintain those weekend contacts with her child while the child continues to attend school and do those things here. Mr. Larson lives in the greater Seattle area. It's unknown what his availability is, but his suggestion essentially is that if my client is in the hospital, then he should be allowed to remove Rue from school, remove her from her environment. We just don't think, given the professional's input and given what's going on, that that's in the child's best interest. If that's the case, then there's no reason why my client shouldn't be allowed to homeschool Rue and that Rue would be able to be in inpatient setting with her. But again, that's a decision, an educational decision that needs to be discussed between the parents and made between them jointly. And again, Mr. Larson is not doing that. He's not involving my client in those decision-making processes. This is not a power struggle over control by my client. My client is attempting to assert herself and hold her ground with an individual who has been identified as having control, anger, and emotional abusive issues that he has not addressed. He needs to participate in the counseling recommended both by Ms. Hale and by Ms. Lovely. And we're asking that the court order him to participate in the 6-month domestic violence intervention program. We're asking the court to order him to participate in the mental health counseling that was identified in Ms. Lovely's report, and I believe also recommended by Ms. Kale. The parent education there should be some effort at him to educate himself as it relates to my client's medical issues. And I guess I don't know how we encourage parents to grow empathy, but this is Rue's mother. My client is in a medical fight of her own. Another one, I mean, this is not unfortunately uncommon ground for my client, but she's trying to do everything possible and listen to all of the professionals, and he needs to be on board with that. We are asking that he participate in a collateralized substance abuse evaluation as was recommended. And I would note that part of Ms. Hale's recommendation was that the paternal grandparents are not to transport Rue. We're asking the court to adopt that provision. There was also a recommendation that transportation be shared between the parties. You'll note that paragraph, currently Mr. Larson is providing all of the transportation for his visitation. Our proposal at paragraph 12 has him continuing to provide that. My client is of extremely limited funds. She does not have the finances available to be transporting to a location equidistant between here and Seattle or here in Yakima, depending upon where he's going to either live or spend his vacation. And all of my client's finances need to be reserved to make sure that she has sufficient funds and transportation available for her to meet her own medical needs. So we're asking the court to adopt our amended temporary order parenting plan as proposed.
Your Honor.
Go ahead.
Thank you. First, we're not asking for permission to remove Rue from Longview, take her out of her school, move her out of her home, move her out of her community. We are literally only asking primarily that there be an opportunity for my client to have right of first refusal to come down and perhaps collaborate with Ms. Larson and her parents, utilizing whatever space is available on their various properties. Regarding the evaluations, Ms. Kale noted no concerns between the father and the child, just that there may be some concerns about the way he behaves in his relationship with Ms. Larson. Further, he is seeking treatment on that end. Again, for both parties, incomes are very tight right now. He's doing the best he can trying to find affordable treatment. My client has and continues to do his very best to abide by the various demands made by Ms. Larson regarding communication with her regarding the child. I think the primary point of contention was, I think this past December, Rue asked her father on the fly if he would stay. He did his best to deflect the question. I believe the maternal grandmother overheard, started her own conversation with my client, and then the rest, of course, was described in the various pleadings. Again, this just also to clarify, this wasn't medical leave. This was paid time off that he used to parent Rue. Beyond that, you know, we are obviously my client wants to maintain status quo, and we disagree with the assessment. Otherwise, and basically, when it comes to the collateralized substance abuse disorder evaluation, we would ask that we go back and discuss same and do something rather retroactive. Otherwise, if the court disagrees, we would ask that if there's no finding of a substance use disorder, that Ms. Larson be ordered to reimburse my client for the cost of that evaluation. Beyond that, I mean, he has worked very hard to work with somebody who is extremely difficult to work with. He is doing his best to work with somebody he has watched struggle through this 2 times previously, and is going to continue to do his best to abide by everything. In the meantime, we are asking that the court permit him to have right of first refusal going forward. The outpatient, as counsel noted in her own statement, does not mean that Ms. Larson is home and caring for her child. Status quo is with a parent, not with the grandparents. Thank you.
Ms. Kale, anything you'd like to say?
Just that I support the notion that Mr. Larson has done everything in his power to, I mean, outside of some of these evaluation recommendations from Miss Lovely, has done everything he can by way of being a parent to be there for Rue in this situation. This is there are some very specific circumstances going on in which we have one parent who lives 4 hours away from the family home that the child's living in and doing everything he can to be as present as he can, while the other parent is in the middle of a very serious medical crisis. I do want to make a note that regarding my transportation recommendation, that they meet halfway, that was before I understood that Miss Larson was hospitalized again for her medical condition. And so I do understand at this point that it is not possible for her to make that trip. And so there needs to be another accommodation. I would be comfortable recommending that the grandparents can support that trip if necessary. The maternal grandparents, that is. I stand by the recommendation that paternal grandparents not be transporting Rue given any number of circumstances. I do think it's important that Mr. Larson continue on with those recommendations made by Ms. Lovely. I want to be clear that Rue has a very strong bonded relationship with her father, desires time with him, wants him, enjoys her time with him. And I support entirely that he have first rights and refusal if Miss Larson is incapacitated and unable to parent. I do not say that to mean that the maternal grandparent should be excluded from that relationship, but only that Mr. Larson is very capable of parenting his daughter. He does need mental health support and he needs help with anger management. Rue is not afraid of her father. I believe that these are adult relationship issues that Mr. Larson carries. But that's what I have to share at this point, Your Honor.
Anything further, counsel?
No.
All right, I did review, filed some record, including the guardian ad litem's report and the recommendations. What I'm going to be going off is I find the proposed temporary parenting plan of the petitioner mother reflects how the court sees what is in the best interest of the child at this time, and I believe it pretty much, unless I missed something, if somebody thinks I did, then let me know. The recommendations other than the first right of refusal, and I'll get to that in a minute. So I will be adopting the parenting plan, the amended temporary order. If in fact, after evaluations are done and the collateral information comes in, says something different than what's in here, then obviously you can bring the issue back and we can relook at this again. But that I have, or it does include about parent has one or more of these problems, for Ryan Larson engaged in domestic violence evaluation with Olivia Lovely. So I guess that's another one that I did not adopt, is that they get to go out and find somebody else to do another evaluation. It will be that of Ms. Lovely. And then the evaluation, collateralized substance abuse evaluation with a provider, that paragraph is in there as well. Limitations on a parent, this will be included. Both the father and mother shall be enjoined or restrained from talking negatively or allowing third parties to talk negatively about the other parent to the child. Father shall provide their current address and phone number at all times prior to their visitation. Both the father and the mother shall be enjoined or restrained from being under the influence or consuming alcohol, legal or illegal drugs, except as prescribed by a treating provider 12 hours prior to or during their residential time with the child. Each parent, requesting parent, may request random observed urinalysis, hair follicle, or nail tests, etc. That's in there. Both parents shall download the Our Family Wizard application as soon as possible at their own expense. All communications between the parents relative to the child and the child issues shall take place through the Our Family Wizard application. Both the father and mother shall be enjoined or restrained from allowing the minor child to be transported by the paternal grandparents, Elaine and Kevin Larson. And then evaluation or treatment required, that paragraph will be included. Decision-making paragraph will be included. Dispute resolution is go to court. Custodian will be that of Athena Larson. School schedule, going to the school-age child weekends every first, third, and fifth weekends as defined by Fridays from Friday at 3:30 p.m. to Sunday at 7 p.m. will be with the father. and then at such time, other times as agreed between the parties in writing, such as through text, email, or written correspondence. Now, the right of first refusal, the reason I did not include that is that right now the child, I can only assume, is going through a difficult time with the mother being sick, and that it is in the best interest of that child to have the stability of what is known, be it the school, be it the activities, be it the bedroom, whatever it may be, that at that time, that's in the best interest of the child to have that stability. And that change is not something that would serve the child well. So that's why I did not do the first right of refusal. It can be looked at again for the summer schedule. That's not quite as complicated as maybe the during the school, as well as to get those evaluations and get that treatment done as well. Holiday schedule, that's adopted. Conflicts in scheduling is adopted. Transportation arrangements adopted. Moving with the child is just a standard relocation language. And paragraph 14 is adopted. That's just general common sense, good common sense. So anyhow, I've just gone through and essentially, like I said, adopted. Is there anything that anyone knows within that parenting plan that does not reflect the guardian ad litem's recommendations? Because I didn't see it other than the couple of things that I talked about.
Not that I'm aware of.
Okay. All right. All right. So with that, I apologize if I misstate your last name. Is it Margraf? Is that how you say it?
It's Margraf, like Margraf.
Margraf. Okay. Are you okay to put approved via Zoom on here?
Yes, please. I'd like some clarification on Thanksgiving.
Okay, just a second. All right, Thanksgiving.
Yana, can we make that from Wednesday at 3:30 until the night before school resumes, so it's a full weekend?
I just intended to keep the weekends intact. So if it's his weekend, it would roll into Sunday anyway. That was my intention.
I don't think that's a problem to make it the whole through the weekend. Let's see, he's coming. Is it? Let's see.
Not even his year this year anyway, but I just noticed and thought that it would probably be a little more fluent to extend it out.
So I'm going to change Friday to Sunday in that paragraph.
In both of them?
Yeah.
Okay, thank you.
And then can I ask for clarification, Your Honor?
Hold on. Okay, go ahead.
Thank you, Your Honor. So essentially, the court is denying right of first refusal in lieu of the parties perhaps agreeing in writing beforehand. So my client's going to have to try to get an agreement from a person who's been extremely uncooperative about a child who needs a parent in place.
Well, I'm saying right of first refusal is not going to be ordered. So if they can agree on something more, then they can agree on something more. But at this point, I'm not doing right of first refusal.
All right, thank you, Your Honor.
They have. All right, thank you very much. I'll provide a conformed copy to both Ms. Margraf and Ms. Kale once it hits Odyssey.
Okay.
Thank you. Thank you, McLean.
Thank you.
Okay. That concludes this docket.